The first 10 amendments to the Constitution of the United States are called the Bill of Rights because they provide basic legal protection for individual rights. The framers of the Constitution, however, did not feel the Bill of Rights was necessary. They believed the national government did not in any case have the power to do what was expressly forbidden by the proposed amendments. Nevertheless, powerful political leaders like Thomas Jefferson, Samuel Adams, and Patrick Henry, who did believe in the Bill of Rights, prevailed. From the time they first settled in Virginia and Massachusetts, American colonists were well aware of the importance of human rights. Their struggle for independence demonstrated to them that rights not written down in constitutional documents were insecure. Shortly after we declared our independence from England in 1776, the individual states drafted their own Bills of Rights, the first being Virginia's Declaration of Rights. This document served as the model both for similar state documents and for the first 10 amendments to the Constitution of the United States.
The Anti-Federalist chief concern was that the Constitution of the United States did not contain any rights of the citizens, any rights of the states.
The Anti-Federalists were men like George Mason and Patrick Henry, who opposed the United States Constitution because they felt it gave too much power to the federal government.
And their concern was this creation of this national government would be much like what they had before with the king in England, that the difference wouldn't be anything discernible. And their request for the Bill of Rights is directly tied to that. In 1689, the English passed an English Bill of Rights.
Anti-Federalists felt it was necessary to have a specific Bill of Rights limiting the power of the federal government in specific protections to the American people.
In the first Congress, the first session, James Madison, who writes most of the Bill of Rights, receives over 200 proposed amendments to add to the Constitution to ensure the rights of citizens against the national government. The Bill of Rights initially, the first 10 adopted, there was actually 12 proposed, but only 10 passed and were ratified. I should say only 10 were ratified and passed. Of those, it only requires that the national government not violate these rights.
The First Amendment is probably the most important of the 10. It states, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances."
If you look at the First Amendment, for example, it says Congress shall make no law. The concern wasn't of state governments. In fact, for many of the citizens at the time, the state governments were the bastions of freedom. It was the national government they were concerned about. So the Bill of Rights initially applies only to the national government, not to the states.
The First Amendment actually contains 4 important safeguards for the American people. The first, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In other words, Congress cannot establish a national religion, nor can it prevent any citizen from attending the church of their choice. The second important safeguard in the First Amendment prohibits the government from abridging the freedom of speech or of the press. Together, speech and press have been termed freedom of expression, a broadly stated freedom that's been the subject of challenges and court interpretation ever since it was written.
The First Amendment protects one's freedom of speech. It includes also the ability to protect your right of assembly, to petition the government for redress and grievances, protection of religious freedom as well.
Freedom of speech is one of the most important liberties granted us in the Bill of Rights. In the First Amendment, we are guaranteed that Congress shall make no law that does not respect our freedom of speech or infringing upon our freedom of speech. What that means is that Congress cannot infringe upon our ability to express our ideas, either verbally or by Supreme Court precedent through the expression of various actions or by our freedom of association with various other individuals.
All sorts of speech is included under the First Amendment. Seditious speech, libel speech, obscenity, pornography. So symbolic expressions such as flag burning is a form of speech. Even giving money to a candidate is seen as a speech right of voting with your dollar, if you will.
Under Supreme Court cases, the First Amendment does not protect incitement to riot and other types of speech that might be dangerous or cause threats to our national security.
Holmes, in a case called Schenck versus United States, said that yelling fire in a crowded theater was not protected, that was seen as a clear and present danger is the test that he uses then. That the reaction to yelling fire would be so immediate and so dangerous to others that word in and of itself, in that context, wasn't protected.
Freedom of speech at its heart means that we are able to express our political viewpoints no matter how unpopular they are.
The First Amendment freedom of speech, it generally, as Justice Black said, is used by those miserable merchants of unwanted ideas. But it's speech we hate, not speech we love, that it is protected here. It's not you and I having a conversation. It's someone saying something that most of us would find a minority view. And the framers were concerned that that minority view be protected.
The third freedom guaranteed by the First Amendment is the right of the people peaceably to assemble. An example of this freedom in action is picketers who may legally assemble to publicly demonstrate their position on controversial issues. The final clause of the First Amendment is very similar, the right to petition the government for redress of grievances. Those who followed Martin Luther King provide a good example. In demanding of the government stronger civil rights and voting rights legislation, and for a meaningful poverty budget, they called for a reconstruction of the entire society, a revolution of values. The Second Amendment to the Constitution is also a very controversial one that's in the news almost every day. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. At the time the Constitution was written, America's Army was made up of state militia. Citizen volunteers and their right to keep and bear arms was important to the defense of our country. In modern times, the defense of the country has been turned over to a professionally trained Army, Navy, and Air Force, but the right to bear arms is still granted to the people of the United States.
The standard interpretation of the Second Amendment is that it allows the arming of the state militias, that the connection of the right to bear arms was always one made with a state militia. It wasn't ever used to argue the right of an individual to own a handgun. This has been an argument, though, proposed by certain interest groups wanting the Second Amendment to be activated, if you will, to cover those claims. Justice Douglas, as late as 1972, said in an opinion that the right to bear arms did not include the right of an individual to own a handgun.
The Second Amendment has never been held to give people an unqualified right to possess any weapons they want. You cannot possess a nuclear bomb simply because the Second Amendment guarantees a right to bear arms. Nor can you possess certain types of very dangerous semi-automatic or automatic rifles through the Second Amendment.
Many individuals do believe that the Second Amendment includes their right as an individual to bear arms. And I think there is a renewed interest in the Second Amendment because the NRA and other interest groups have been so interested.
According to Supreme Court cases, states may regulate the ability of citizens to own guns or other types of weapons.
There's even a case in 1999 in which a federal judge ruled that the right of an individual to obtain a handgun is covered under the Second Amendment. Now, whether that will be appealed or not is another matter. Again, the mainstream thought is that it doesn't include that but there has been some push in litigation to have it include the rights of individuals regardless of the connection to a state militia.
The Third Amendment stems from treatment citizens received from British soldiers. It states, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." Before the Revolutionary War, British soldiers would force American citizens to take them into their homes and give them food and shelter.
Secure these homes! Secure these homes! Accommodations for 3 nights!
The Third Amendment makes certain this never happens again, even in time of war, unless ordered by a court of law. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." A person's property can be violated, however, with the consent of a court if a search warrant is issued based on probable cause. A judge will not grant a search warrant unless there is good reason for it.
The Fourth Amendment deals with unreasonable searches and seizures that in these 54 words that the framers protect you against unwarranted searches and seizures. This comes again from the colonial era in which the colonists were regularly searched and seized without search warrants. Even in England at the time, there were searches with what were known as general warrants. They didn't specify time or place, the thing to be searched, the place to be seized, and they were just pieces of paper that allowed the king's men to search someone in a sense of a fishing expedition. In the colonial times, for example, even the Boston Tea Party is an offshoot of an illegal search and seizure. The seizure of this tea that didn't have a stamp to follow the Stamp Act, the colonists threw it in the water rather than have themselves subject to an illegal search and seizure. But by corollary, it doesn't disallow those that are considered reasonable. There have been a lot of exceptions to when the police can search you without a search warrant, times when it seemed as reasonable for them not to have one. For example, in your automobile, that because of the exigency and the mobility of a car, that it would be unreasonable to require the police to go back and get a search warrant to search your car when they stop you for a vehicular violation. So it's reasonable to search without one. Most of the Fourth Amendment has come down to a balancing test between the greater good of society being served by excluding evidence versus the right of the individual to be searched. If evidence is seized illegally, the courts have required that it be excluded from use, and that's been the remedy for the Fourth Amendment violation.
The Fifth Amendment enumerates several things the government cannot do to individuals. No person shall be held to answer for a capital crime or other infamous crime unless on a presentment or indictment of a grand jury, except in time of war. The amendment continues, but let's examine the first part of it. A grand jury is a body of citizens chosen to review the facts surrounding a criminal case. Their job is to decide if a crime has actually been committed, and if so, if the person charged is likely to have committed it. Only then can he or she be held to answer for it. There are some important additional concepts established in the Fifth Amendment. No one can be tried twice for the same crime. This is called double jeopardy, and a person may not be compelled in a criminal trial to be a witness against himself.
The Fifth Amendment protects you from being a witness against yourself. It also includes the right to have a grand jury, the right to be protected against double jeopardy, the right to confront witnesses against you. But it's the self-incrimination provision that most people know, and they know it from television mostly, I should say.
So that in a court of law, you can exercise your Fifth Amendment right against self-incrimination and refuse to answer questions. This applies only to criminal law, however, so that in a civil trial, such as President Clinton versus Paula Jones, you must answer any question posed to you, and you cannot exercise a Fifth Amendment right to not answer self-incriminating questions in a civil trial.
The third additional concept established in the Fifth Amendment is that a person cannot be deprived of life, liberty, or property without the due process of law. In other words, imprisoned without a trial.
The difference between the Fifth Amendment and the Fourth Amendment is that oral testimony is seen as inherently unreliable, whereas no matter how I seize a gun or a knife from you, it's still reliable evidence. It's still probative in value, whether I seized it illegally or not. But whether I seize your testimony, whether I coerce it out of you, I can change the reliability of it. So the idea that that someone is read those rights, they're warned ahead of time that if they do say something, it can be used against them, is one that most Americans support.
And the fourth additional concept established in the Fifth Amendment, nor shall private property be taken for public use without just compensation. Progress demands that the government be able to build new bridges and roads and public buildings. But the government must pay a fair market price for the land needed for these improvements. The Sixth Amendment to the Constitution describes rights that you have if you are arrested. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial by an impartial jury of the state and district wherein the crime shall have been committed.
In actuality, however, the vast majority of criminal defendants never choose to exercise their rights and take a plea bargain offered them by criminal prosecutors. The reason why the American criminal justice system operates at such a high level of plea bargains is because it is a very long process to go through a formal trial, and it often is much easier on all parties concerned to simply have a plea agreement.
Our courts are tremendously overworked. The average time from filing to trial in federal district court is about 2 years if one doesn't sign certain waivers to a trial by jury. Many cases are dispensed with in the justice system without a jury trial. They're done before a judge. But the argument for a jury, most Americans find that to be a touchstone of our system, that we allow other citizens to play an active role in one's guilt or innocence.
This clause of the Sixth Amendment guarantees every citizen of the United States as fair a trial as we in Western civilization have been able to devise. It may not be perfect, but it's the fairest court system of any country on earth. The Sixth Amendment guarantees us information telling us what we are accused of doing so that we can prepare our defense. We have the opportunity to see and hear those who are accusing us. We are given the help of the government in bringing to court witnesses who can help us, and we have the right to a court-appointed attorney if we can afford a privately retained attorney. A famous court case in 1966 involving a defendant named Miranda established that the police must inform you of your rights.
The Miranda warnings require that the police tell you that, first of all, you have the right to remain silent. Secondly, that anything you say can and will be used against you in a court of law. Thirdly, that you have the right to an attorney. And fourth, that the right to an attorney cannot, if you cannot afford one, that one will be provided for you. And then lastly, you're asked if you understand these rights.
The Seventh Amendment extends the right to a jury trial in federal civil cases as well as criminal cases. The Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
The Eighth Amendment protects one against cruel and unusual punishment, and that has been interpreted to mean two things. One, that the punishment in and of itself is cruel, that the form of punishment is seen as torturous or barbaric. The rack and screw, water torture, all sorts of forms of punishment in and of itself. The second interpretation of what cruel and unusual punishment is that the punishment doesn't fit the crime. For example, in 1958, there was a case in which a deserter from the military is stripped of his citizenship. That was seen as cruel and unusual, that the punishment of loss of citizenship didn't seem to fit the crime. So those have been the two definitions of what that means.
At the founding of our nation, it was not considered cruel and unusual punishment to lock someone in the stockades in the town center. Currently, however, this would be considered cruel and certainly unusual. At the founding of our nation, it was not considered cruel and unusual punishment to commit someone to death for various acts.
It's to this amendment that opponents to the death penalty cling when arguing that the death penalty constitutes cruel and unusual punishment.
Most of the time when we think of cruel and unusual punishment, we think of the death penalty. The courts have ruled fairly consistently that it's not seen as cruel and unusual to execute someone for certain crimes. There are a lot of technicalities about when the state can use the death penalty, in what context, how death penalty cases are treated in the judicial system. But the punishment itself, per se, is not seen as unconstitutional.
In the modern era, the Supreme Court first put a halt to all executions and prohibited the death penalty, but later reinstated it as being constitutional. Since that time, the Supreme Court has actually tried to help speed up the rate at which executions occur, shortening the appeals process that criminal defendants are entitled to.
The other part of the Eighth Amendment where some of the newer litigation is coming is the three strikes and you're out provisions. The provisions of mandatory punishment, mandatory life punishment, which is an interesting problem administratively in that most citizens are for it. It is the tough crime provision, but at the same time our prisons are full of people committing 3 felonies, but not necessarily violent felonies, maybe for example 3 drug felonies, and we have prison overcrowding as a result. There are other provisions such as is imprisonment cruel and unusual? Is certain forms of imprisonment cruel and unusual? For example, prison overcrowding, the fact that certain qualities of prison life, is that cruel and unusual? So it taps into more than just cases of the death penalty. But that's where most of the litigation is, I think.
The Ninth Amendment establishes this guarantee. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This is a catch-all amendment which grants rights which may have been overlooked in the first 8 amendments. Court interpretations have now included things like a person's right to privacy and the right to take part in political activities. The 10th and final amendment in the Bill of Rights asserts that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This is a final guarantee that the federal government will not and cannot take away personal rights.
The 10th Amendment, which is the reserve clause that reserves power to the states and the people, was placed there for the framers to quell the fears of citizens, to say, what if there's not other enumerated rights here? Can the national government disclaim them as their own? And the rulings of the 10th Amendment have said that all powers not given to the national government and not prohibited to the states are reserved to the citizens.
As John Adams, our second president, put it, "You have rights antecedent to all earthly governments, rights that cannot be repealed or restrained by human laws, rights derived from the great legislator of the universe." These are the 10 amendments that have come to be known as the Bill of Rights. In countless other countries around the world, people have no Bill of Rights to protect them from excesses of government authority. But in America, the Constitution and the Bill of Rights guarantee us the rights to life, liberty, and the pursuit of happiness. The first 10 amendments formed the groundwork for the people's rights. As our country grew, more amendments were added to keep pace with changing times, but only 17 in a period of over 200 years, making a clear statement about the sound basis on which our Constitution was founded. This is an amendment to Article 3, Section 2 of the Constitution, which gives certain authority to the federal court. In 1798, this was amended to prohibit a citizen of one state or a foreign country from suing citizens of another state in a federal court. The matter must be decided in a state court. The 12th Amendment changes the way in which the Electoral College chooses a president and vice president. This amendment grew out of a problem Congress experienced during the election of 1800. The Constitution instructed electors to vote by ballot for two persons. The one receiving the most votes would become president. The one receiving the next greatest number of votes would be vice president. All electors in the Democratic-Republican Party voted for Thomas Jefferson and Aaron Burr, creating a tie vote. Most wanted Jefferson as president, but when the tie vote was sent to the House of Representatives to be broken, the Federalist Party members almost succeeded in making Aaron Burr president. The 12th Amendment requires the electors to vote for a president and a vice president on separate ballots, eliminating the possibility of a tie. The amendment gives us greater assurance that the voter's choice will be president. The 12th Amendment did two more things. It gave instructions to the Congress that if a new president had not been chosen by Inauguration Day, March 4th, the vice president shall act as president on a temporary basis. In addition, it made it clear that a vice presidential candidate must have the same qualifications for office as a presidential candidate. The American Civil War brought about many important changes to the nation, including some new amendments to the Constitution. The 13th, 14th, and 15th Amendments are called the Reconstruction Amendments, since they put into law certain conditions resulting from the Civil War.
The Civil War amendments, the 13th, 14th, and 15th Amendments, come about almost as a requirement for the South to come back into the Union. The three of them taken together are concerned with the issues of slavery.
The 13th Amendment put an end to slavery in America. It states, "Neither slavery nor involuntary servitude, except as a punishment for crime, shall exist." The 14th Amendment has become one of the most important parts of the Constitution. It's divided into 4 sections. The purpose of Section 1 is to make citizens of former slaves. It states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Section 1 goes on to establish this important doctrine. "Nor shall any state deprive any person of life, liberty, or property without the due process of law." The scope of the 14th Amendment has broadened since it was written. It now gives citizen rights to all who have come to America from other countries once they become naturalized citizens, and it ensures that fair legal methods are used when a person's life, liberty, or property is in question. The Due Process of Law Clause is generally regarded as being protection against violation on the state level of individual rights which are guaranteed in the Bill of Rights.
The Due Process of Law Clause is located two places in the Constitution, in the Fifth Amendment and in the 14th Amendment. One applying to the national government in the Fifth Amendment and one applying to the states. Due process means that one has the process due to them. The courts have ruled it means procedural regularity and fundamental fairness, and requires that systematically each of us is treated the same in the eyes of the law. That the courts don't make any distinctions about us, whether we're rich or poor, black or white, male or female. There's also a large body of law dealing with what's called substantive due process, that the substance of the law in and of itself can't treat us unfairly, that laws can't make in their substance distinctions about us that are unfair.
The final phrase of Section 1 is one of the most important in the Constitution, that as citizens we all will have equal protection of the laws. Whatever rights are given or rules made, they must be the same for everyone.
The 14th Amendment guarantees numerous rights. Probably the most important part of the 14th Amendment is that it applies directly to the states, meaning that states cannot infringe the rights of American people. Previously, the First Amendment, for example, says Congress shall make no law. The 14th Amendment says no state shall. And what that means is the 14th Amendment, in applying to the states, limits the state's ability to hurt the American people.
Sections 2, 3, and 4 of the 14th Amendment are now obsolete. They had to do with a change in the way the census was taken, punishment of Southern congressmen who rebelled against the Union prior to the Civil War, and the denial of the government to honor debts incurred by the Southern states in their rebellion against the North. The 15th Amendment represents a very important step forward for our country. It gives the right to vote to citizens regardless of their race, color, or previous condition of servitude. This amendment was specifically meant to grant voting privileges to slaves who became free following the Civil War, but it extends the right to vote to all men regardless of race or color. Notice we said all men. At this point in our nation's history, women were still denied the right to vote. It's a serious problem that wasn't corrected for another 50 years. The 16th Amendment is a law we're reminded of every April 15th. It gives the government the right to levy a tax on personal income from any source. Many people have tried to avoid paying income tax, saying it violates some constitutional right or it violates some moral belief. There have been many challenges, but none of them have been successful. In fact, evasion of income tax has even been used to put away some criminals like Al Capone when other laws failed to convict. The government's need for revenue is enormous. It takes a great deal of money to maintain all the departments, the military, the country's infrastructure, and to pay the many men and women who work for the government. Income taxes represent the greatest single source of this revenue. The 17th Amendment changes the way in which senators are elected. Originally, according to Article 1, Section 3 of the Constitution, senators were to be chosen by their state legislatures. In 1913, this was changed, giving the voters the responsibility of choosing the 2 senatorial representatives from each state. The benefit we derive is greater control over the Congress and senators who are more ready to listen to the will of the voters. The 18th Amendment outlawed the manufacture, sale, or transportation of alcoholic beverages. During the 19th century, a movement was building among people who were opposed to intoxicating liquor. They encouraged laws that would make alcoholic beverages illegal. The cause became known as the temperance movement, the word temperance meaning control or abstinence. They even formed their own political party, the Prohibition Party, and ran presidential candidates. In 1917, their cause got an unexpected boost from World War I when the government sent out the message to conserve grain needed to make bread. In 1919, the Women's Christian Temperance Union and politically strong Anti-Saloon League were victorious when the 18th Amendment was passed and ratified. Finally, in 1920, women earned the right they had always had but were denied, the right to vote. Like the temperance movement, women's voting rights grew out of protests from concerned citizens. Women like Susan B. Anthony, who is recognized as the leader of the women's right to vote cause, and others such as Elizabeth Stanton and Lucy Stone. Their cause was known as women's suffrage. The word suffrage simply means the right to vote. With the passage of this amendment, no adult, regardless of race, color, or sex, can be denied the right to vote.
It is certainly the case that American society's treatment of women has grown much more equal over time, but it has been late in coming.
The 20th Amendment changes the dates newly elected officials take office. When the Constitution was written in 1787, the fastest means of travel was by horse. It took weeks for people to receive mail or get from one part of the country to another. The Constitution therefore allowed newly elected officials voted into office in November 4 months to get to Washington in time for inauguration March 4th. In 1933, when this amendment was ratified, transportation was greatly improved. Congress was finally able to address an underlying problem. Under the original law, the president didn't start doing the job he was elected to do until 4 months after the election. What was worse, Congress, which didn't convene until December unless the president called a special session, could go as much as 13 months before starting their work. This became known as the lame duck Congress, because Congress could include congressmen who had been defeated for re-election. Amendment 20 is sometimes called the lame duck amendment. It orders newly elected congressmen to begin their work on January 3rd, about a month and a half after election, and it orders the new president to take office January 20th. The amendment also added stipulations of how to handle a situation whereby a newly elected president or vice president died before taking office. The 21st Amendment repeals or overrules the 18th Amendment. Rather than achieve its purpose, Prohibition gave criminals a rich new business. Americans were not about to give up their beer, wine, and liquor, even if it meant buying it from bootleggers who operated illegal manufacturing plants and secretive saloons called speakeasies. Public pressure made it clear to Congress that the lesser of two evils was to make the manufacture, sale, and transportation of alcoholic beverages legal, with one notable exception. The states are given the right to continue the ban or put tight controls on its sale. None decided on continuing the ban, but in many states like Utah and Pennsylvania, the importation and sale of alcohol is controlled by the state. The 22nd Amendment puts a limit on how long a person can serve as president. Only one president has served more than 2 terms in office, and that was Franklin Delano Roosevelt. This amendment states that no person shall be elected to the office of president more than twice.
The 22nd Amendment is passed to ensure that the presidency doesn't become a job for elder statesmen, and it sets the limit at 2 terms. The maximum number of years that someone could serve as president is 10.
The specific wording says that if more than half of the term has already been served, the vice president is entitled to serve out that term and also run for election twice.
If someone served 2 years and 1 day of the previous term of a president, either by death or disability or resignation, then they would only be eligible to run 1 time after that, so it would be a maximum of 6 years.
The 23rd Amendment gives Washington, D.C. a number of electors of president and vice president equal to the least populous state. The Constitution provided for members of the Electoral College to come from the various states. Washington, D.C., however, is not a state, but a district established in 1800 as the seat of our federal government. Consequently, the citizens who live in our nation's capital didn't have a vote in presidential elections until after that problem was corrected by this amendment. The people of Washington, D.C. now have the same number of electors as the least populous state, which is Alaska. Amendment number 24 makes it illegal to charge a poll tax or any other kind of tax as a requirement for having the right to vote. The 1960s saw many improvements in our nation, especially in the southern states as regards civil rights for African Americans. In certain southern states, poor African Americans were virtually disappearing from the voting rolls because of their inability to pay these unfair taxes. The 24th Amendment put a stop to this type of discrimination. The 25th Amendment clarifies ways in which Congress must deal with vacancies to the office of President and Vice President. 8 presidents died while in office, and their vice presidents took their place. The Constitution never meant for the Vice President in this instance to become the President, but rather merely to serve as acting President. This amendment actually gives him the title of President and gives him the power to name a new Vice President.
Well, the 25th Amendment guarantees that when the Vice President ascends to be President, that they have the full powers of the Chief Executive as if they were elected President. That when they hold the office, they hold all the powers of that office as well.
When John Kennedy was assassinated and Lyndon Johnson became president, there was no vice president for a period of about 1.5 years. There was concern over this because the next in line to be president, the Speaker of the House, was over 70 years old and not fully capable of taking on all the duties of the president. The 25th Amendment was intended to replace a vacancy in the vice presidency, which had been overlooked in the Constitution. The president has the power, when there is a vacancy in the vice presidency, to appoint the vice president with approval of the House and the Senate.
Yes, the 25th Amendment also includes in its provisions a hierarchy of ascension, that if the president is incapacitated, resigns, retires, dies, that the vice president ascends. If that person is not available, it's the Speaker of the House. If that person is not available, it's the President pro tem of the Senate. And then after that is the cabinet officers in order of their creation. The more interesting part of the 25th Amendment is the what-if question of presidential disability. There have been a number of times in history where presidents have been disabled and have not necessarily relinquished the reins of presidency to the vice president.
Woodrow Wilson suffered a debilitating stroke in his second term of office. Mrs. Wilson was widely perceived to be the effective president of our nation during that time. FDR, during his 4th term, was very ill and in fact not fully capable of functioning as president.
Probably the most recently when President Reagan is shot and does not give up the reins of the chief executive, even though he's undergoing surgery to remove a bullet from his chest. Later on, Reagan actually undergoes some surgery and issues one memo or a small memorandum to Congress, which says that his long-standing agreement with Vice President Bush was that while he was under general anesthesia, that Bush would have all the powers of the chief executive. And later on, he takes that back when he's fully capable and not incapacitated.
Numerous examples exist to show that there are times when the president is not fully functional, and because of the importance of the presidency, particularly in the nuclear age, we need to have a functional president at all times. Therefore, the 25th Amendment allows for the easy succession of the presidency during times of operations, during times of incapacitation, or other emergency provisions.
The 26th Amendment extends voting privileges to citizens 18 years of age or older.
The Constitution has made the right to vote easier and easier in that we've almost got to 100% of what's called enfranchisement or the ability to vote. That through a number of amendments we've allowed women the right to vote, blacks the right to vote, 18-year-olds the right to vote, that we've created an environment where more and more Americans are eligible to elect people. Senators are now directly elected. We've eliminated the poll tax as a provision to vote. So many of the amendments deal with that concern of the right to vote.
The most recent amendments to the Constitution have primarily been around the right to vote.
Actually, of the last 12 amendments, 6 of them have increased the right to vote or made it easier, eliminated barriers to the right of voting.
The 27th Amendment places restrictions on congressional pay raises. Although Congress may approve cost of living increases in their salaries, which immediately take effect, if they approve a pay raise, it will not benefit the Congress putting it into law, since it will not take effect until the next election of representatives to Congress. Interestingly, this amendment was written by James Madison, one of the founding fathers, back in 1788 as part of the Bill of Rights. It didn't receive enough votes for ratification at that time to become an amendment. 9 of the 13 original states would have been needed to pass it. But the Constitution places no limit on the time allowed for the states to ratify an amendment. And when Congress passed legislation in the late 1980s granting themselves immediate pay raises, the proposed amendment found renewed interest. The votes in favor cast by states way back in 1788 were still good. The additional votes were gained, and the necessary 3/4 of the states voted in favor of making this the 27th and most recent amendment to the Constitution of the United States. In a way, we've come full circle, the most recent amendment being one that was introduced by James Madison, the man who is called the father of the Constitution. The Constitution, the Bill of Rights, and the 27 amendments to the Constitution are a national foundation for freedom and democracy.